Okay, Judge, we're ready.
Okay, if you both unmute, please. Okay, if you'll unmute, please, sir. Thank you. All right, if you both raise your right hand. Do you swear or affirm testimony you're about to give in the matter pending should be the truth, the whole truth, nothing but the truth under penalty of perjury?
Yes, Your Honor.
Okay, do either of you have any additional witnesses besides yourselves?
No, Your Honor.
Just the grandmother is here. My mom is here.
Okay, she's going to need to be in a separate room. She cannot sit in the hearing at all until she's called in as a witness. She needs to be in a room where she cannot hear any of the testimony going on today.
Okay.
Okay.
All right. I can go in another room.
Okay, thank you. And please close the door.
You're welcome.
All right, let me explain to both parties. You're here on two motions. The petitioner has a motion for permanent order, which basically means a 3-year order. It's not technically permanent at this point. And the respondent has filed a motion for reconsideration because the motion for reconsideration has to do with the underlying order. I'm going to hear that first. I did not hear your original 12-month case, I don't believe. So it's going to kind of be fresh, but I need to find out what that motion is about first. Both motions have been properly served, it appears, by law. So we can hear both today. Each of you have the burden of proof under the law by preponderance of the evidence. That means the greater weight or more likely than not. If you do not meet that burden, then I cannot grant your motion at all. So please understand that. I realize our staff has alerted me to the fact that you have an order or you have a case pending with Judge Heydrich. Is that a divorce case?
It's custody, Your Honor.
Okay, custody case. Okay, were y'all married at one point?
Yes, Your Honor.
Yes, Your Honor.
Okay, and okay, who originally under the divorce had primary custody?
I did, Your Honor.
Okay.
I had physical custody.
Okay, that's the main thing. Usually it's joint legal and then one party has physical. Okay.
We had joint custody. Yes, Your Honor.
Okay, and under the protective order issued previously in this case, that was transferred to the petitioner, Mr. James. Is that correct?
Yes, Your Honor.
Okay. All right. Ma'am, if you will, tell me why you're asking this court to reconsider the order that was entered previously in this case.
Yes, Your Honor. The petitioner put a lot of faulty information in his original order. So I'm just going to kind of go in order of what I have here. I do have evidence of the call logs. He's been saying that the child was abandoned at the police station. I did call the petitioner several times. I did enter that for evidence because I began to have insomnia. And I was calling him to let him know that I needed him to get the child because I was going through mental health crisis. So as I said, the call logs have been entered. He was also supposed to get the child for his birthday, and he never does get him for his birthday. I don't even know if he usually celebrates it. As far as I know, he never has. And this was his actual weekend to pick the child up at the police station. So that's why we were there. So the petitioner was using his right of refusal, which he often does use. There's even been a time where I kept the child for a whole month and he didn't see him at all on his request because of COVID. I did also submit that I was in the hospital on the day that you all actually had court for this case. That paperwork has been submitted. Right now with the order in place, I can't go to church. And I feel like that's important to me. The petitioner put that I was schizophrenic. I'm not schizophrenic. He's basically just trying to weaponize my mental disability, which is one of the reasons why I left the relationship. He has been known to be verbally, emotionally, and psychologically abusive, and he's admitted to that. I submitted that for evidence as well, I believe. Basically, what has happened is that he's taken the child and refused to return him. He was supposed to do supervised visits because we did have another DFCS case by me going to the police station. And I reached out to Mr. James several times about doing the supervised visits. He never followed up with that with DFCS. And then he didn't allow any contact with me from the child. I was calling, trying to see how his day was going. And he's basically just been really keeping the child from me. We had come to court previously because I think we went 5 or 6 months without any contact with Mr. James and without me seeing the child. So that's been an ongoing issue. The petitioner put that I caused him to get an eviction notice. I submitted that he had an eviction notice. I don't believe he was evicted, but it is in the system on Odyssey that he had an eviction notice before this event ever happened. It states it was in December of 2021. Let's see, I already said that he's presented faulty information. He said that the child was with his grandparent, which is really confusing for the child because he's calling people the grandparent and the godmother, and they're of no relation. My child has never had godparents. My mom is the only grandparent that he has, and the petitioner has a father that lives in New York, and those are his only 2 grandparents. I'm asking as well for modification so I can go to talk to my son's teacher. I am an educator, and I want to be able to know what's going on with him at school and how he's doing. And even if something happens with him, like be able to talk to the school nurse. I want to be able to support my child, with positive behaviors. The only thing I've ever told him is that I love him and that I care about him. And just to discuss any negative behaviors that he may do, because he is only 8 years old now. I did take a parenting class as well, Your Honor. I submitted that for evidence to help my son with his behavior issues. And he needs a behavior plan to be created, which I've been trying to work on that for the longest time. But I want to be able to get that done with his teachers. I have my compliance letters to show that I've been doing my treatment. And the child was taken from his custody. I actually don't know where the child is at this time. They said they were going to close the DFCS case, but I don't have any evidence that the DFCS case has been closed. But the child was taken from Mr. James' custody for abuse and neglect. And with some of the findings, I was informed that he's denying the child food as a form of punishment, makes him write sentences, and all that is not good for him, coming from an educator's perspective. And as a fellow parent, it's not good for him to deny him food or, do some of the things that he's doing. There's other ways to discipline the child. And then he's also putting his hands on him, and he's not supposed to do that. So I'm just really concerned about my son. My son doesn't like the supervised setting. He wants his mom. He's told me he wants to come back with me. He wants to be back in his room. He wants his things at home. So a lot of what the petitioner is saying is going against what the child needs and what he's saying he wants.
How old is the child now? Excuse me for interrupting.
He's 8.
Okay.
He just turned 8 on July 9th.
Okay. All right, go ahead. I'm sorry to interrupt.
No, that's fine. I know it's a lot. He's been missing his therapy appointments. And at this point, it's really important that he goes to his therapy appointments. The child does. He needs to have consistent sessions with his therapist. I have consistent sessions because we did have domestic violence, a lot of arguing and fighting that was not easy to tolerate. So our son does need like a trauma-based therapy. He's been ripped from the home at this point. And then his dad has also been hitting on him. So he really needs to make sure that he's doing his therapy. If there were any way that you could order for us to do some kind of family counseling, I feel like we really need that. Because we need to be on the same page. That's all I've ever wanted for us. But it's like we're unable to get on the same page, and I don't understand why. I feel it's for the best interest of the child, that he knows that he's supported and shown love from his family. And his dad has really been isolating him. Like through the visitation, he won't allow anybody that my son wants to see, his cousins, his uncles. He won't allow anybody to see him. He's just isolating him. And I know that's probably very hard on my son, because he's already said, during the time that the DFCS case was open, he said that, and this is all recent stuff. I don't know.
We don't have the child here to testify. The child's too young to testify. And I don't generally allow children of that age to provide any testimony at all. So please do not refer to what the child may have told you. That goes for both parents. I can't hear that.
Okay.
This is between the parents. Children of that age do not get to decide where they're going to live. Once you're in court,
Right.
then it's the court's responsibility, mine and Judge Heidrich's, to determine short-term and or long-term custody of this child.
Yes, Your Honor. I just know that he's, being isolated from his family in general.
Did you have any evidence or documents you wanted to present to the court?
I have from Nia's place, the denial. I could get that. I didn't know that I would need it, but
I didn't know if you'd filed anything did you file anything with the clerk's office for this hearing?
I did file evidence, Your Honor.
Okay, then if you want the court to see it, you have to tell us what it is, and the staff will pull it up so we can all see it.
Okay, so we can do that. Because I was basically finished. The only other thing is that our child.
That's why I was asking you if you had anything you wanted me to see.
Yeah, the call logs. I sent the call logs.
All right, just give them a minute to pull it up.
And I tried to submit everything in order.
Judge, I think this may be it. Is this it, ma'am?
Yes, those are the call logs when I called.
What is the purpose of this document?
This is just the evidence that I did reach out to Mr. James before going to our pickup spot, which is the police precinct. I reached out to him because I was going through a mental health crisis. I had gone through insomnia, and whenever I have insomnia, that's a warning sign for me. So I did call Mr. James to let him know that I needed him to get the child, and this was his weekend to get the child. All
right, let me explain. We're not going to retry the case from almost a year ago. Okay, you're asking this court to reconsider an order that's already 11 months old.
I'm just letting you know that I never got to submit the evidence, so I do have the evidence submitted.
Okay, well, we're not going to retry the case. You have to show the court why it should be reheard before we'll start looking at evidence that would.
And I have.
Case.
Okay, with my filing, I did submit my discharge paperwork that you were looking for last time that proves that I was in the hospital. So maybe you want us to see that. That was filed with my.
Okay, Judge Edgerton heard your case. I didn't.
No, I wasn't there.
Okay. Judge Edgerton heard this case and entered the 12-month order. It was not me.
I understand.
Okay, so why are you saying something I asked you to do?
Well, it was someone else that I came to court with in June, and they told me that I needed to have evidence that I had been discharged from the hospital, and I do have.
Okay. All right, if you wish to
I
show
thought
me
it was you. I'm sorry, Your Honor. It was someone else.
Maybe it was. I can't remember all my cases.
How did you label that? Was it a DFCS letter?
That one was filed with my actual evidence when I put in the filing for the case.
So what's the name of it?
For the reconsideration, motion for reconsideration.
Okay.
Okay,
so
well,
motion for reconsideration.
Yeah, okay, hold on a second here. What I'm looking at in the court clerk's file is that, ma'am, you filed a motion for reconsideration that was filed on September 13th last year. And,
This,
and then Judge Edgerton on September 19th denied that motion. And then 2 days later, you filed a motion again for reconsideration. Is that correct?
those did not include the evidence of that I
Okay,
was.
is that correct that you filed it a
Yes.
second time after he had dismissed it?
Yes, Your Honor. I didn't
Okay.
have evidence at that
Okay,
time.
well, you don't get two bites at the apple, as they say. So,
Yeah, Judge, this one is showing June 28th.
Yes, this is from June 28th.
yeah, I guess I was just looking at the filing dates.
She said she attached it. She did a motion and attached her evidence to the motion.
Right, but that was the second motion, the one from September 21st. Is that correct?
Motion for September 6th, 2022. This one was filed on June 28th, 2023.
So this is a third motion for reconsideration.
I think so. I haven't counted all of them.
Okay, this order is up for expiration. I'm going to deny the motion for reconsideration. We're not going to retry a case that has less than a month to go.
Well, Your Honor, he's trying to make it for
Ma'am,
3 years.
I have ruled that this court is not going to reconsider this case that is 11 months old. It's a 12-month order. And it's actually less than a month to go. All right, next I will hear the motion for permanent order filed by the petitioner. All right, sir, you can tell me why you want a permanent order, why you feel there's a need for it.
Okay, can you hear me, sir?
Yes, sir. Yes, sir.
Can you hear me?
Yes.
Okay. The reason why I filed a petition for extension on the restraining order is because Judge Heydrich does not have us on the docket to see our custody case. So with the restraining order ending September 5th, she can come and get the child at any time, which is putting Josiah in danger. She abandoned the child last year. She, under supervised visits, she has basically given him gifts and took those gifts back. I have allowed I have allowed his grandmother to attend those visits, and the grandmother has even took the gifts back from for his birthday party that they had at the supervised visit. So that is the reason why I'm filing for the extension on the restraining order. Also, prior to the restraining order, there was no calls made to me. I actually have text messages saying that see you at the end of the summer when school was ending of May 2022. So I was trying to get verification because I only had visitation at the time before the restraining order. So she basically said to me, see you at the end of the summer. I said, what does that mean? And she did not respond. She also she had 2 birthday parties for him in the summer of 2022, and she attended both of them. She abandoned the child July 14th after his birthday. So she had 2 birthday parties for him and then abandoned the child at the police precinct, which was that Thursday. She has not been to a church in a few years. I've never ordered her to do the supervised visits. That was a court order through Judge Edgerton because he heard our case. She does know his godmother, which is Miss Butler. She attends our church. We both know her for over 10 years. So she's saying that she is no family to us. Well, she is like family to us because she is well aware of the case, and not only that, she's very close to Josiah. Hold on 1 second. She was not consistent with therapy when she had Josiah, the custody. I have been consistent with taking Josiah through his therapy sessions. Also, Ms. Butler, who is his godmother, has been attending those therapy sessions and been heavily involved. He even had more therapy sessions since he's been in my custody due to the restraining order, because his behavior has totally dramatically changed since he's been with her. I have a letter from the director of the school saying that his behavior has changed. So we're trying to keep those therapy sessions as we're trying to keep them up to date, and as much as we can. We attend all the supervised visits. We have not missed one. If I'm unable to take him to a therapy session or a supervised visit, Ms. Butler is on the approval list to drop him off and pick him up for those therapy sessions and the supervised visits. Oh, also, I submitted to the courts today a letter from the pediatrician stating that he is in better care with me since his behavior has changed since he's been with me. The pediatrician has seen her behavior and his behavior, which was a total concern for the pediatrician. She has not been compliant with the pediatrician to get Josiah seen for other tests to be done about his behavior. And we have took the necessary protocol to get him checked out due to what has happened with the traumatic experience that he has been with her. And she did not call and leave me a message on July 14th when she abandoned him at the precinct. The police actually called me because to come and get the child. And how they were able to call me, she had to call his auntie in Alabama to get my number because she erased my number out of his phone. So, Your Honor,
the child, 8-year-old child has a phone?
Yeah, he had a phone since he was 6 years old, Your Honor.
Okay.
And I was totally against that, but she got him a phone anyway. She would use the phone as a form of harassment, calling me hours of the day when he's trying to sleep. And not allowing him to even spend time with me when when the visitation was going on. She would interfere with that. So she would use the phone as a form of harassment. Also, she used the police as a form of harassment by doing child checks. So we would be having dinner and we would get at least 3 to 5 child checks during the week. So she was using that as a form of harassment. I also submitted a letter from my leasing office stating that.
Sir, let me. Yes. Sorry to interrupt, but let me explain a couple of things. I can't look at letters sent by people. That's what's called hearsay.
No, it's a witness affidavit.
Sir.
No, it's a witness affidavit.
Okay, sir. Guess how long I've been doing this a long time, sir. Affidavits are not admissible. They're hearsay. They're not here to be cross-examined. So I can't accept any letters or affidavits from anyone. The same as I said, I can't accept what an 8-year-old child tells both of them. Man, please put your hand down. This is his turn. Okay, go ahead, sir.
He has also been traumatized over the past few years when the police and the ambulance.
Sir, again, I apologize. Let me tell you what I'm here to do.
Okay.
It's not to hear anything that occurred before you got your 12-month order.
Okay.
Only what has happened since the 12-month order that leads you to believe that this child is in some kind of danger. That's it. What has happened since the filing of the 12-month, since the granting of the 12-month order that leads you to believe that upon expiration of this order, that there's some danger to the child, and that is the basis of the need for a permanent order?
Well, Your Honor, she has shown up to the school unannounced.
When was this?
This was in May of this year.
Okay.
Yes, it was in May of this year. She showed up to the school saying that I was abusing the child, and I was not abusing the child. I was disciplining him by spanking him because of something that he did at school. The counselors was aware of the situation, They knew that that I disciplined him, and she used that me spanking him and left a mark on his arm. So defects got involved. The defects spoke to the counselor at the school. They spoke to me and spoke to Josiah. Josiah was removed from the home and given to the godmother, which is she is a part of the safety plan. The defects did not find any evidence towards the case. Matter of fact, when I mentioned the restraining order to defects, they did not give me any documentation that evening or even throughout this period.
Where's the
So
child now?
the child is with the godmother.
And how many months has that been? I do remember I did hear part of this case back in February.
Yes,
So some of this is coming back about the birthday parties and the mark on the arm.
yes. So, but there's no so
So the child is with the godmother right now.
the child is with the godmother right now. I am allowed to see the child and spend time with the child, to have the child. The defects case has been closed because there was no evidence found that I was abusing the child.
Well,
I
why
took
isn't the
it.
child back with you?
Now, what you said, why is the child not back with me? He is back with
Yes,
me.
sir. That's what
But
I asked. Where's the child now? And you said with the godmother. You
Yeah,
mean
he's with the godmother. He's with me.
Oh.
We work together to take him to school and all of that.
where does the child sleep at night? With the godmother?
He sleeps with the godmother, and then he'll sleep at home with me.
Okay. Do you have a copy of any release by DFCS that you wish to show the court?
Yes, I do, Your Honor.
Okay. If you filed it with the court, I'll take a look at it.
Okay, I could send that over immediately.
No, it's too late now. You're supposed to file any evidence beforehand.
Yes, Your Honor. When we went to court in June of,
Which court? This one or Judge Heydrich?
no, it was another judge that we went for a hearing. It was an emergency hearing that she filed for. And the judge at that time said for the child to stay with the godmother because Josiah being transferred back and forth was too much on the child. So to let him stay until the custody case was solved.
And y'all have not solved it in Judge Heydrich's court yet.
Yeah, Judge Heydrich has not seen the case because we met in April and she pushed it back to August, and we're not on the docket for August. And we don't know when we'll be on the docket. That's why I'm filing for the extension on the restraining order to keep Josiah protected, because he will be in danger if he does go back with her. I don't know if she would take him out of state. I don't know if she will harm him. Like that, I don't want to run the risk of him being hurt by him being in her presence.
Okay, and other than the abandonment, as you've alleged at the police precinct, what else? What other harm are you alleging has occurred?
When she would show up to the school, he would be afraid to go with her.
No allegations.
To the school?
No allegations of physical harm, though, correct?
No. Josiah saw her at the school and was afraid she was going to take him away.
I think your video has gone off. You got another picture here.
Can you see me now?
Yes.
Yes. Josiah was at the school and he was afraid that she was going to take him away. Also, when he would go to the supervised visits, he would always come back mad or angry, upset, and not wanting to talk. So I don't know there's supposed to be a mediator in the room with them, but Josiah is not calm. He is very agitated when he gets in the car. He doesn't want to, not that I'm forcing him to speak on what is going on with his mother, but his behavior definitely changes when he does see her. He acts out in school when he sees her because he's very upset and angry with her. So he does not feel safe or feel comfortable because he is basically traumatized, and what keeps replaying in his mind about the police coming to the house, her being taken away in an ambulance. He's also upset now that his birthday just passed in July, and she took the books that she bought for him back. So Josiah said to me, well, why would she buy the books and give them to me and then take them back?
I can't hear from the child. He's not here. He's too young. Okay, please, both of you.
No, I have a text.
Both of you are cautioned. Do not tell me what the child has said. I can't hear it.
No, she has sent a text message, sir. She has sent a text message to Miss Butler stating that she would want whatever items he is not using back.
Ms. Butler is the godmother.
Yes, sir. Yes, Your Honor.
Okay. Did you file that text message with the court that I can see?
No, Your Honor. I can send it over,
Okay.
but
all right.
She's also stating that I've been evicted from my residence, Your Honor. I have a screenshot of the lease for the 3 years that I've been there. Miss Connie is the office manager. She was there when she showed up that day, accusing me of abusing the child. I have a text message saying for me to call the office. The police was on the premises.
Okay, your screen is frozen.
Can you see me?
Yes, I can now. Last word I heard was premises. All right, you're still frozen.
No, that's it.
Okay, all right, ma'am, you wish to respond?
Yes, Your Honor. A lot of the allegations and stuff that he's talking about is all before the order was made. I do have, like I said, the evidence of the call logs, and he was also talking about the same things with the I have the hospital visitation. He was talking about something else. The eviction notice. I never said that he got evicted, but I do have that labeled with my evidence that his apartment number, if you can pull it up, is that eviction notice. It doesn't say that he was evicted, but he did get a notice in December.
Okay, well, if that's
he's saying that I caused it, but it's
okay,
not true, Your Honor.
Okay, I don't care who caused it. Are you still living?
Your Honor.
Okay, the fact that it was an eviction notice and it got cleared up, is there an eviction pending in court?
No, Your Honor.
Okay, are you paid up on your rent there?
Yes, Your Honor.
Okay, let's move on then, ma'am.
Yes, I do have a motion to modify, so I would be able to talk to his teachers. Like I said, I am a teacher as well, and I want to be able to communicate with my son's teacher about his behavior. As far as him misbehaving, he's been misbehaving. He's still misbehaving. I don't know if the petitioner submitted his report cards, but he still has ins and U's in conduct. And that's just how my son is. And I'm not going to say it's probably because of the divorce and other things. He just has those issues. A lot of the stuff he's saying, he's fearful to come to me. I don't know where any of that is coming from, because it's just opposite of what I'm being communicated to, Your Honor, but I respect that you're saying we don't need to get that. Now, I do have the notes from the DFCS case that happened after the protection order. I do have that for evidence stating from DFCS everything that has been happening. If you wanted to look at that as well.
Yes, tell us how you labeled it, and we'll pull it up.
I honestly don't remember what the label is, but it's all attached in one. I think it might be D. I'm not sure. Yes. So that's what I gathered from DFCS. It's several pages documenting what all they're doing in the case, what's going on. And
Hey,
so,
we're okay, ma'am. Let me look at it.
okay, yes, Your Honor, no problem.
The document will speak for itself.
Yes, Your
You
Honor.
don't need to tell me what it says.
Yes, Your Honor. I apologize.
Okay. Ms. Broom, can you enlarge it just a little bit, please? Thank you. Either that or I need to get some stronger glasses. Okay, so this first page, ma'am, is what you told DFCS, right?
I believe so, Your Honor.
Okay, well, I need to see what DFCS has done at the end, not what somebody alleged.
That is the only page that I did. Everything else, I believe, is from them. Because the first was a call from the abuse from him leaving a mark on his arm.
The next page.
Thank you, Your Honor.
Okay, next page, please. Okay. Can anyone tell me on this document where it's been redacted that the child stated he feels safe in the household with, and then it says, then it's redacted?
I'm not sure, Your Honor, to be honest.
Okay, I'm going to assume it's the petitioner, Mr. James, because it talks about his spanking for kicking a kindergartner. Okay, it says that the child understood why he was being disciplined and that he understood that he was in the wrong. All right, next page, please. Okay, next page. All right, next page. All right. Okay, anything else in this document? Or is that
Just
all?
the pages there, Your Honor,
Okay,
that I'm concerned about how he's taking, denying him food and making him write sentences And that's the part I'm concerned about, and him putting his hands on him, because Mr. James is larger than I am, and my son is smaller than we are. And I'm just concerned about him putting his hands on him. I understand as far as him disciplining him, but we do have a court order through Judge Hydrick where there's not supposed to be any corporal punishment, which is why the petitioner had to take a class. But I don't know if he's going to not whoop him. He says that he won't. But I'm just concerned about him leaving marks and things on our child like that. I don't do that.
Well, both of you are concerned about each other. And the child knows this. The child knows that both of you are fighting. And the child learns from y'all's behavior what's going on. That's why the child's up and down right now, probably. Confused, upset. I'm assuming that he loves both of you.
I believe he does, Your Honor.
Sir, do you believe he loves both of you?
Yes, Your Honor.
Well, y'all got to fix this. You've had DFCS, you've had this court, you've had Judge Hydrick's court, 3 different entities involved in taking care of your child. And that's not right. I mean, we're here to do it because we have to sometimes. But until the 2 of you get on the same page in your divorce, in the custody case. So when were you divorced? How long ago?
March
2021. March.
Okay. So a couple of years ago, 2.5 years ago, whatever. And I'm sure it's been off and on between the 2 of you ever since.
No.
And the more you keep it up, the more this child's going to suffer. All right. I'm going to eliminate this court. This order is going to remain in effect until September the 6th. I find that there's not been a preponderance of the evidence met by the petitioner to extend it to a permanent order. Judge Hydrick has this case. Both of you are under her authority as well. So I do not anticipate any future danger to the child, because if either one of you does, then you're going to be in serious jeopardy in front of Judge Hydrick. Yes, sir.
Your Honor, if she comes and gets him after September 5th and she has an episode that could further traumatize him, that is putting the child in danger.
Sir,
allegation.
I do not have a crystal ball here.
Not only
sir, I'm not going to argue with you about my decision.
I'm not arguing.
You can go get all the legal advice you want to about the what ifs.
I'm not arguing.
Either party has the right to file future temporary protective orders, whether it's September 5th, 6th, 7th, or never. You have the right, if something else occurs, to file for a new protective order. Man, put your hand down. I'm done hearing both sides. I'm not modifying the current order. I'm not extending the current order into a permanent order. We are eliminating one of the courts that y'all have to deal with. You have to deal with Judge Hydrick. If anything happens there, then either one of you will suffer the consequences with regard to any custody modification in that court. They can appoint, Judge Hydrick can appoint a guardian ad litem to come and inspect both of your homes, to basically do what DFCS does, to check into the home life of the child. They can interview witnesses, neighbors, children, everybody, and make a recommendation to Judge Hydrick on future custody of this child. But there's not been sufficient evidence for reconsideration, no sufficient evidence for modification, no sufficient evidence for a permanent order to be entered in this case. I will do my paperwork hopefully this afternoon. It'll be filed with the clerk's office. And you'll receive copies through them. That concludes the case. Both of you are excused.